offender. Romans 5, accused himself must have the necessary intention to commit the offense. Brackets, intention to form of dolus eventualis suffices. In S versus Tebus and another 2003, brackets 2 SACR 319CC at 345D, the trial court must determine in respect of each accused person the location, timing, and sequence, duration, frequency, and nature of the conduct alleged to constitute sufficient participation or active association in its relationship, if any, to the criminal result and to all other prerequisites of guilt. Whether or not active association has been appropriately established will depend upon the factual context of each case. S versus Toby 2004, brackets 1, SACR 530, brackets W at 549D. The principle to be extracted from these authorities is relatively plain, where a group of persons act with a common purpose. The unlawful actions of one member will be attributable to the others in the circumstances where such actions must have been foreseen and therefore, by inference, were foreseen as part of the general plan. 3. Plea. Both accused pleaded not guilty to the charge and elected to disclose their defense in terms of Section 115 of the Criminal Procedure Act 51 of 1977. Number 4. Plea explanation in terms of Section 115 of the Criminal Procedure Act 51 of 1977. 4.1. Is that one of justification. Both accused believed that they were entitled to enter the cemetery for the burial ceremony and that the obstruction of them was illegal and unjustified. 4.2. In the circumstances, they lacked mens rea because they believed at the very least that they were entitled to enter the cemetery for the burial. 4.3. I record that there is a political agenda here. This is an assault common case. They both reached out to the complainant by process of Ubuntu that was rejected by AfriForum. So this turns out to be political. Well, that there is a political agenda between AfriForum and the EFF that is being played out in this court. 5. Principles applicable to the charge. Milton, South African Criminal Law and Procedure, 1996, Volume 2, 3rd edition, 405 defines assault as: assault consists in unlawful and intentionally 1. Applying force to the person of another, or 2. Inspiring belief in that force is immediate to be applied to him. Snyman on page 430 defines assault as follows: assault consists in unlawful and intentional A. Applying force directly or indirectly to the person of another, or B. Inspiring belief in another person that force is immediately to be applied to her. Elements of the offense. 6. The act. 6.1. Application of force, brackets, or the inspiring of belief that force is to be applied. This element manifests itself in two ways, namely through the application of violence and through threats of violence. The slightest application of force is sufficient to establish the act. 6.2. Unlawfulness. The test whether the conduct is unlawful in a given set of circumstances amounts to a punishable infringement in the eyes of the public. In the judgment of Botha AJ in A, citation 1971, brackets 2 SA 293T, the legal conviction of the community requires that the physical integrity of the person should be protected. 6.3. Intention. The perpetrator must have the intention to apply violence to another person or to threaten him in such a way that a belief or fear is inspired in the mind of the latter. Number 7. Requirement 7.1. There has to be a threat of personal violence. This implies that once a threat is at something other than the complainant's person, it does not constitute assault. 7.2. The threat has to be one of immediate violence. The application is force, or force is the key fact of assault. Number 8. Facts not in dispute. 8.1. The date, the time, the place, and the identity of the parties are not in dispute. 8.2. Colonel Venter, the complainant, is the one who stopped the vehicle wherein the two accused were passengers therein. 8.3. There is no version from either accused that they did not assault the complainant in this regard at the time when the complainant testified. A version regarding this aspect came to light during the presentation of the defense's case, wherein the accused explained what transpired on the day that resulted in the unlawful assault on the complainant. 8.4. There was no dispute that Colonel Venter was going to get permission from the Winnie Operations Center, brackets walk, to allow the accused vehicle to enter the premises. 8.5. Reference is made to Section 174, judgment wherein the following finding was made by the Honorable Court. Therefore, I find that there is common cause between the state and the defense in terms of Exhibit 3. It is admitted by consent, and the court ruled that it is also admissible as evidence before the court. Reference also with transcript of 28 October 2020, page 82 and 84. Real evidence consists of things which are examined by the court as means of proof upon proper identification, and it becomes of itself evidence as to what was said in the case of S versus Matembo 2008, brackets 2 SACR 411, SCA at 31. Real evidence usually based on...
We're going to be dipping in and out of this story as the details come through, but right now the prosecutor reading a summary into record.